Hi, I'm attorney Chris Reich, and in this video I'm going to discuss failure to appear and what it means. A lot of times you will see this failure to appear related to a traffic case, both civil and criminal. First, let's talk about criminal. When you receive a criminal traffic ticket, you're going to get a complaint, a ticket from the officer. It's going to have a court date on there when you got to show up. If you fail to show up on that court date, the court is going to say that you failed to appear. What does this mean? When you fail to appear, the court is going to add another criminal charge. There's actually a criminal charge for failing to appear. It's a misdemeanor. They're going to add that on to your case. They're going to issue a bench warrant for your arrest to compel your appearance in the case. They're going to issue a license suspension order as well until that warrant is quashed. How do you handle a failure to appear? Every court's going to handle this a little bit differently, but there are a few possible ways that you may be able to handle your failure to appear. One, you can show up to court and make an appearance. Most courts will have what they call walk-in hours, where you can just show up and get in front of the judge, and then you could ask the judge to quash the warrant, get rid of the warrant, and reinstate your license. The judge might also require the payment of a bond to make sure you appear in court in the future. So the bond is usually going to be $500 or the equivalent to whatever fine is owed. And at the conclusion of your case, that bond is either applied to any fines that are due. If no fines are due, if there's excess, you would get a refund for that bond. Sometimes you can get rid of the warrant and get your license reinstated just by paying the bond amount without having to show up. Sometimes, if you have an attorney, we could file a motion to the court asking them to quash that warrant and reinstate your license. Sometimes the court will go ahead and do that without the payment of a bond and without a personal appearance. So really, it's hard to tell without calling the court and asking them what their process is to take care of that warrant and license suspension. Even after you get your warrant quashed and you get your license reinstated, you still have the failure to appear charge associated with your case. Now, a lot of times when you resolve your case, say you reach some sort of plea agreement with the prosecutor or with the state, part of that agreement will be that that failure to appear charge is dismissed. Rarely do we ever see that charge stick. Usually we're able to negotiate that away, but if you went to a trial, you're probably going to lose on that charge. We also see failure to appear applied in civil cases, but it's a whole different situation. They use that same terminology, and that's what gets really confusing. But in a civil case, a failure to appear is more like a default judgment. It's not a separate charge. Procedurally, what happens, in a civil traffic ticket, same thing. You're going to get a ticket. It's going to have a court date on it. If you fail to show up for that court date, the court is just going to enter what's called a default judgment against you. That means the court decided you knew about the ticket, you knew about the court date, and you willfully chose not to show up. So the court's just going to find you responsible for the civil traffic violation. They're going to impose a sanction, which is a fine. And then because that fine is not paid, they're going to suspend your driver's license until it is paid. No separate charges or anything like that. It's not criminal. There's not going to be any warrant issued in a civil traffic case. But the biggest problem is that license suspension. So to take care of a civil failure to appear, basically a default judgment, you have two options. One, you can just pay the fine, and then you have to pay a reinstatement fee to the Motor Vehicles Division, but that would take care of the suspension. The other possibility is you can motion the court to set aside the default judgment. This means you're basically saying, hey court, I had a good reason for not showing up for my court date. This is why I didn't show up. Please set aside the default judgment and let me either challenge the case in a civil traffic hearing or let me do defensive driving school. If you have no defense and you can't do defensive driving school, you might as well just pay the fine because you're not going to get any benefit from going through the effort to set aside that default judgment. It is the court's discretion to set aside a default judgment as well. So even if you make that request to set aside the default judgment, the court doesn't necessarily have to grant that, and that might mean your only option then is to just pay the fine to take care of that license suspension. So hopefully that clears up the difference between a criminal failure to appear and a civil failure to appear. If you're dealing with a failure to appear and you're not really sure what steps to take, give us a call. We can give you some direction or help you out.